Hi, I'm Chad Mead. I'm an attorney at Fenimore Craig. I practice in the firm's executive compensation and employee benefits practice group. I'm going to talk to you about medical loss ratio rebates that are issuable under the Affordable Care Act. Insurers that didn't spend enough of the premiums on healthcare services or improving healthcare services, typically between 80 or 85%, depending on the size of the plan, are required to issue a rebate by August 1st, 2012. Employers need to determine what to do with these rebates, and they're probably going to receive questions from employees because these insurers had to issue notices both to the employers and to employees saying, we're going to issue these rebates. So the first question and the major question you got to ask yourself is whether these rebates constitute plan assets. If they do, you've got to return them to the employees in some form or another. Basically, if you don't have plan documents or some other extrinsic evidence that says whether or not these are plan assets, the DOL is going to look at whether the premiums were contributed by employers or by employees or both, and that will determine. If they're, to the extent that they're contributed by employers, they will not be plan assets, and the employers can keep the rebate or that portion of the rebate. If they're contributed by employees, then they are plan assets, and you've got to return them. The Department of Labor gives you a number of ways you can do this. You can cut checks to the employees, paying them in cash. You can increase the benefits that you get under the plan, or you can give a premium holiday, so to speak, where employees don't have to pay contributions for a certain period of time. This last approach is the one that we like best because it's the cleanest. You're going to have most contributions made under the plan are going to be on a pre-tax basis, and so the rebates that you're going to receive are going to be taxable. Now, if you decide to cut a check, for example, it's more complicated because not only do you have to go through the process of cutting the check, and you also have to withhold taxes on that. With the premium holiday, anybody that's included in it, sure, their pay is going to increase, and that will be taxable, but it's just going to be treated under your normal payroll procedures. So we like this approach. If you have plan assets, they're going to be subject to ERISA's fiduciary rules, so you have to come up with an objective, reasonable basis to allocate the rebates. And just because somebody received a rebate in it or made a contribution in 2011 doesn't mean that they have to receive a portion of the rebate in 2012. You can come up with a reasonable allocation. Typically, people that are participating in the plan or even COBRA beneficiaries that are participating in the plan can be included in the premiums holiday. We think this is the best way to go. There are other alternatives, and if you want to discuss them, you can call Fenimore Craig attorney. We hope this helps. Thanks.